Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a judge who gets it. More on that in just a moment. It isn't every day you get a message on your computer that says a judge has made an important ruling in a bankruptcy case. But indeed, that has happened in the Purdue Pharmaceuticals bankruptcy. So let's talk a little bit about how Purdue became embroiled in bankruptcy and sort of the behind the scenes, the inside baseball on what's happened. So Purdue Pharma produced this drug called OxyContin. Purdue Pharmaceuticals was owned by a family called the Sackler Family. There were several people in the Sackler family who were very high up and had board positions and who had basically financed the company early on, had large blocks of stock, and they created this drug called OxyContin. They were the first to produce it. They were the first to come out with a really good synthetic opioid, and they marketed it under the belief, or I should say under the assertion, that it was less addictive than opioids, direct opioids like morphine, for example, or Demerol. And that was simply not the truth. In fact, it was more addictive, and most people who get onto it, sadly, cannot get off of it. It becomes a way of life for them. And that's especially true with people who have chronic pain. And again, that doesn't necessarily mean there's a moral failing for the person who can't get off of OxyContin. It is a biochemical process that is very, very difficult to break. Addiction specialists have been trying for 20 years to try and figure this out, and they still haven't. But at any rate, Purdue and companies like Endo and Teva and Mallinckrodt marketed these products in such a way as to emphasize the safety of them to the physicians. But they were not safe. And thousands upon thousands of people became addicted to them. And when the doctors realized that they had become addicted, they did what a responsible doctor does in that situation. They cut them off. And then these people would go to pill mills, to doctors who are so inept at practicing medicine that the only way they can stay in business is to write prescriptions for OxyContin for people who have terribly painful conditions like dehydration, which, by the way, is not that particularly painful. But at any rate, these people would go in, pay the money to the doctor, he'd give them a prescription for OxyContin, off they'd go to the pharmacy and they'd fill it. And they'd come back 2 weeks later, get another prescription and go to a different pharmacy. Well, pretty soon a lot of those pill mills started getting closed down and people became aware that these drugs were not safe and were not used, even if used as the way they were intended, they produced a more likely than not period of addiction to this drug. So what happened? The lawyers got involved. Often, once you get into the approved category of a drug with the FDA takes the view that, well, we couldn't have done anything wrong. The drug must be fine. It must be all these nutballs out here. Well, it's not all those nutballs out there. What it is a bunch of people who are becoming addicted to a drug that feeds on that addiction. And if you sell more OxyContin because people are addicted to it, well, it then becomes sort of a self-enriching prophecy. You have this great drug that kills pain, but it also boosts profits almost logarithmically. So, Purdue grew and grew. It had huge profits. And of course, the Sackler family benefited greatly from those profits. And then the first of the lawsuits hit. And when the first of the lawsuits hit, the Sackler family began taking all of their money out of Purdue Pharma. And they left it in a cash-poor position. And they basically said, okay, yeah, take us into bankruptcy. We don't care. So they took them into bankruptcy, and they put together a plan of reorganization. Now, of course, in a bankruptcy, you have not only the creditors of the estate, like the people who sold them the ingredients to make their drugs, and the workers who work the drugs, the pension plans for those workers, all of those things are there in the bankruptcy trying to get some share of whatever value is left in that company. But you also have the lawyers who are trying to sue for clients all over the country. You have the attorney generals of all the different states who are trying to sue to recover Medicaid funds because a lot of Medicaid money was spent on all of these drugs. And together, the value of those claims far exceeded the net worth of Purdue Pharma, at least the net worth as it stood. So what happened here is people started to think, maybe we should go after the Sackler family. Maybe we should go after them and get their money since they took money out. And so the Sackler family, who still had a role at the drug company, they still had membership on the board, they said, look, we're not going to agree to any plan of reorganization that allows you to come after us. So we either get a release for our conduct, meaning nobody can sue them, nobody can take any of the billions of dollars they pulled out of the company, or we're not going to approve your plan of reorganization. You're going to get whatever you get if we get liquidated, meaning they sell off all the assets. So that was what faced Judge Drain. Judge Drain was the bankruptcy judge in the Southern District of New York who was hearing this case, and he had on the one hand a group of litigants who wanted to get money someday, and on the other he had a group of people who were willing to contribute a little bit of money, but they wanted complete releases from any kind of recovery from anybody else. That was a condition of them agreeing to the bankruptcy. So Judge Drain gave it his best consideration, and he approved it, and he approved the releases. But there were some people who objected to those releases. One of them was the United States trustee. He's sort of the referee in some of these cases. He works to make sure that the process is fair and transparent. And the trustee said, whoa, Haas, hang on a second here. This isn't right. You should not give them a release in this case, because anybody who wants to sue them should go after them. They are not the company. They're just people who profited from it. But the judge, again, said, well, I'm sorry, that's just not going to happen. We're going to approve this plan of reorganization. So the U.S. trustee and a bunch of others appealed. And let me read to you what the Judge McMahon, said about this particular issue. And I'll put it up here on the screen for you to see. The judge wrote as follows. Appellants, that's the people who are attacking the plan, attack the legality of the plan's non-consensual release of third-party claims against non-debtors on a number of grounds. They argue that the release, referred to in this opinion as Section 10.7 shareholder release, is both constitutionally defective and not statutorily authorized, that the bankruptcy court lacks constitutional authority and subject matter jurisdiction to approve the release to carry out certain gatekeeping aspects of the plan that relate to it, and that granting a release to the non-debtor Sacklers is unwarranted as a matter of fact and would constitute an abuse of the bankruptcy process. Now, as in every case, the other side gets to have their say, and the Sacklers, in the form of the debtor, had this to say: debtors and those who voted in favor of the plan, buttressed by Judge Drain's comprehensive confirmation order, argue that the bankruptcy court had undoubted jurisdiction to impose these broad third-party releases, insist that they are a necessary feature of the plan, point out the tremendous public benefit that will be realized by implementing the plan's many forward-looking provisions, and urge that the alternative, Purdue's liquidation, will inevitably yield far less benefit to all creditors and victims in light of the cost and extraordinary hurdles that would have to be surmounted in order to claw back the billions of dollars that the Sacklers have taken out. And here is what the problem was for the reviewing court. The court said, the great unsettled question in this case is whether the bankruptcy court or any court is statutorily authorized to grant such releases. The issue has split the federal circuits for decades. While the circuits that say no are united in their reasoning, the circuits that say yes offer various justifications for their conclusions. And, crucially for this case, although the Second Circuit identified the question as open back in 2005, it has not yet had the occasion to analyze the issue. And then the court says, this is not going to be okay. She says, this will no longer do. Either statutory authority exists or it does not. There is no principled basis for acting on questionable authority in rare or unique cases, especially as the United States Supreme Court has recently held there is no rare case rule in bankruptcy that allows a court to trump the bankruptcy code. The judge then goes on to say, hey, the lower courts need an answer to this question. And so she provides one. She says, aided by superb briefing and argument on both sides of the question, and by extended ruminations on the subject by several esteemed bankruptcy judges of our own district, Judge Drain not the least, this court concludes that the bankruptcy code does not authorize such non-consensual, non-debtor releases, not in its express text, which is conceded, not in its silence, which is disputed, and not in any section or sections of the bankruptcy code that are read singly or together, that purport to confer generalized or residual powers on a court sitting in bankruptcy. For that reason, the confirmation order and the advance order that flows from it must be vacated. Now, the reason this is so significant in the law is that basically what it does is it tends to declaw conspiracies. Where Company A and Company B work together and they are going to harm the public good, and Company A has to go into bankruptcy, Company B will say, well, we're going to sue for indemnification and we need to be released too. And some of these bankruptcy judges have said, yeah, that makes sense, okay. Without realizing that they are taking away the rights of all the people who would sue Company B without any due process. None. So, that's the story on releases and the Purdue Pharma bankruptcy. I thought you might be interested in that, and I would appreciate it if you haven't already to go over here and subscribe to our channel. Leave any comments down below in the comments section. And most importantly, if you'd give me a thumbs up here on the channel, that would really help me with the YouTube algorithm. Thank you so much for watching. Have a wonderful day.